Breaking tonight, we are getting exclusive new details on the massive trove of evidence in the criminal case against 6 cops in Baltimore that has inspired riots, protests, and questions about an increase in violent crime across this country. Good evening and welcome to the Kelly File, everyone. I'm Megyn Kelly. We learned late today that the investigation into the death of a sometime drug dealer named Freddie Gray has produced some 300,000 pieces of evidence against the 6 police officers who now face a list of charges up to second-degree murder. Sources who have seen this evidence or have been told about it are tonight telling the Kelly File that while all 6 officers have spoken with investigators, the officer who is facing the most serious charges has not said anything of substance. We'll show you why that is important in a moment. The Kelly File also learning that at the heart of the evidence turned over to the defense is a police interview with this man, Donta Allen, the only man who was actually in the police van with Freddie Gray on the day he was injured, and who allegedly told police that he could hear Freddie Gray trying to injure himself. The Washington Post broke that story, which Mr. Allen thereafter tried to deny to the media.
Now, the story is, according to a newspaper report, the Washington Post, that there was screaming in the van, that you said that he was intentionally screaming and hurting himself.
Untrue.
Okay.
Very, very, very untrue. Very untrue. I never talked to no investigators. I never talked to nobody. I got my own personal lawyer who I haven't talked to all day because of the madness that been going on. The only person that I talked to was homicide. And the exact same story I'm telling y'all, I told them.
We'll see. Mr. Allen went on to tell reporters that all he heard was, quote, a little banging. And he added that he, Mr. Allen, is, quote, no snitch, and that police, quote, are crooked. But tonight, the Kelly File has learned the Washington Post apparently had it right. A source close to the case telling us there is actual videotape of Donta Allen telling police that Freddie Gray was repeatedly banging his head against the van, that he sounded like a madman, and that he was asking himself why the cops would put him in a van with a crazy person. Mark Eiglarsh is a criminal defense attorney and former prosecutor. Arthur Aidala is a Fox News legal analyst and New York trial attorney. Guys, thank you for being here. And so Donta Allen, who tried to retract his initial statement to the police once it became clear to him how it would appear to others, you tell me, Arthur, how that's going to play to a jury when he is on camera, on tape. The first statement to the cops is that he thought Freddie Gray was trying to hurt himself. He heard Freddie Gray banging his own head against that police van repeatedly, and he wondered why they would have put him in the van with a crazy person.
Well, let me just say this. It's very credible that he would be on videotape. It was common practice. When I was a prosecutor in Brooklyn 20 years ago, it was an audio tape, a cassette tape. But now with technology, on a murder case, any murder case, and you have a key witness like that, you are going to memorialize it so that for this specific reason of locking him or her into a statement. So what's going to happen is that will be played by the prosecutors. He'll have to be denying
by the prosecutors. It'll be played by the defense.
I'm sorry. That will be played by the defense, although you never know, Megyn. Sometimes the prosecutors will play it to take the wind out of the sails of the defense. And that, ladies and gentlemen of the jury, is reasonable doubt. That is reasonable doubt whether the police officer driving this vehicle or any of the 5 caused his death.
Mark, here's one of the reasons why it seems like such an important fact, because we are being told that the one officer who hasn't spoken is the driver of the van, Officer Goodson. And according to the reports that came out on Friday, that's when the evidence was turned over to the defense, they said, oh, all 6 cops have spoken. Well, we learned today that that's not really true, that Officer Goodson, he's top left, has not really spoken. He may have issued some short, brief statement like, talk to my lawyer. But substantively, we're being told he has not spoken. So you've got the driver of the van not speaking, and now you've got the only other person who was in the van, the first statement to the police, before he understands what the media is going to do to this, what his friends are going to do to this, says it sounded like he was a crazy man and he was trying to hurt himself.
Yeah, extremely compelling that the driver is not speaking. The only way that they could possibly prove second-degree murder is if there was some type of admission by the driver that he said, we're going to give him one of those rough rides. We're going to slam on our brakes because this guy was causing us trouble. Absent any statement like that, coupled with this guy that we just saw being their star witness, they've got a serious proof problem.
And Donta Allen actually went on to say in that CNN interview, it wasn't a rough ride. So it would have had to be a rough ride prior to him getting in the van, which, by the way, is the prosecution's theory. But the prosecution's theory does not square with what the testimony is going to be from the only other person who was inside the van, Arthur, who's going to say, when I got in, it sounded to me like Freddie Gray was next to me, because they can't see each other, hurting himself. I'm not saying, I don't know what to believe about Donta Allen and what he experienced, but that's reasonable doubt right there on a second-degree murder charge against that driver.
And he's the best evidence. He's the only person who's back there. None of the police officers are back there with him. He's as close as he can be. And his testimony, the way we understand it, is not going to be he was moaning or in pain or asking for help. It was that he sounded like somebody who was very agitated. And again, Megan, I mean, you can't. A judge almost has to dismiss it after the plaintiff's case, the people's case. There's not enough.
They don't have the proof. They don't have the proof. And now we learn, Mark, that the prosecutor, this is so interesting to me, is trying to divide the defendants. And a lot of people thought, all right, there's 6 defendants. She's going to take the 2 who chased after Freddie Gray and did the arrest before he got in the van. She'll try those 2 together. And then everybody who came after that, she'll try those 2 together. But she's not. She's mixing and matching. She wants 2 tried, and then she wants the other 4 tried. But it's not the 2 on foot versus the 4 that came after. What is she up to?
Well, there's one single reason why she's doing that. Her chances of securing a conviction against all of them as charged is getting someone to point their finger at someone else and give them something that the evidence doesn't support right now. That's what she's doing. It's completely transparent to me.
She's trying to get somebody to flip, and yet I can also report tonight the Kelly file is informed by a source close to the case. No one has flipped on the others.
Nor should they at this
cops
point.
are standing shoulder to shoulder right now, Arthur.
And that's definitely the way it appears as outsiders looking in. But also, Megan, prosecutors do split up trials. It's called severance motion. Sometimes defense attorneys do it. Sometimes the prosecutors do. Don't forget, one witness that goes on now that the prosecutor puts on will be cross-examined potentially by 6 defense attorneys. They get pulverized usually. So if you could cut it back from 6 to 4 and you make the story a little easier for a juror,
all right,
that usually is in their prosecutor's best interest.
Last question. One of the things that they have turned over in this evidence is statements by the cops themselves. You tell me, Mark, whether those are coming into evidence, because normally a cop gives a statement when he makes an arrest. He's doing it in his role as a police officer. He hasn't been Mirandized. He doesn't realize this statement could be used against him in a criminal trial.
I think it generally comes in. If they had these people come in and said, we're conducting an investigation, by the way, you're free to go, they're not in custody. Miranda rights must be read when someone is being questioned, which they were. But secondly, they were in custody. They weren't in custody. They were free to go. And so I think that those statements will probably come in.
You agree with that,
Professor Eiglosh hitting the nail on the head. Absolutely.
Is that right?
Yes, but when people think, oh, I wasn't Mirandized, that's only when you can't leave. When the cops put the cuffs on you, or they put you in a jail cell, or they say you're not going anywhere, then you have to be Mirandized. But if they just come up to you and say, what do you know, or what did you see, when you say, oh, I did the homicide, that comes in.
All right.
That's
Great discussion. Great to see you both.